Ramstrom?
Yes.
All right. We will go on the record in the matter 26 CM 28, 26 CM 29, State of Wisconsin versus Matthew Ramstrom. The state appears through District Attorney Kevin Schmidt in person. Mr. Ramstrom appears by telephone conference with approval of the court. We're set today for a status conference. Mr. Ramstrom participated in and completed a domestic violence course through an online course. The offer was to have him do the Dave Hatch Restorative Justice course and plead to an ordinance violation. Mr. Ramstrom, were you able to complete that program?
I thought it was like the whatever you sent me on. I Googled it and I did the one.
Again, we went over this at the last hearing. We went over this at the last hearing that was what the court ordered on your bail bond. But that is not the offer from the state. But I do have.
Now you want me to meet with a guy, with some fella?
That's Mr. Schmidt.
Okay.
No, Mr. Schmidt is looking at the case. He's the district attorney. He has final say in the cases. This is an actual ADA case, but the ADA is off today.
Because that course definitely covered a range of things.
It's not for you to negotiate with the court. It's not a negotiate with the court thing. It's a negotiate with the district attorney.
I see that my assistant reviewed what he did online. He did think it should satisfy it. So my indication here is because he did that, the offer would be DC for costs only.
So plead to a disorderly conduct?
Yes.
Not an ordinance, the misdemeanor.
That's what his notes seem to indicate.
All right. So he will accept that course that you did, and the offer is plead to a disorderly conduct without any domestic abuse attached for costs only. Are you accepting that offer, Mr. Ramstrom?
What does that mean? That I still pay a fine?
Yeah, it would be a fine, a court fine for the case.
Yeah, like we were talking before?
Correct.
Okay. And then it's just closed and
then it's closed and done.
Okay, yeah, because this has been exhausting.
All right, so you are appearing by telephone conference. Do you understand you have the right to be here in person?
Yes, Your Honor.
And do you wish to settle this matter and take a plea and be sentenced by telephone conference?
Am I looking at like jail time or something?
The offer is for just the fine.
Okay. Like no probation or jail and nothing like that?
Well, that's what the offer is from the state. Yes, to plead to a disorderly conduct for a fine only.
Okay, which is like I don't get it. Like you're trying to put me in jail?
Mr. Ramstrom, the offer from the state is plead to a disorderly conduct. They're going to recommend to the court that it's only a fine. Yes, the court could. If I thought that this was serious, if I thought that this was cray-cray serious, and that you should be punished more, I could, as a judge, punish you more, and I could, as a judge, sentence you to 90 days of jail. However, the recommendation from the state, because you did that program and it exceeded what they were expecting, is for costs of fine only.
Okay.
So do you wish to accept that offer?
Yes.
All right. And you're pleading and being sentenced by telephone. Do you wish to continue today by telephone, or do you want to set it up for an in-person date?
For what?
To be
payment?
To be here, sir, for court.
Okay.
I need to know if you want to take care of this today by telephone, or if you want to say, you know what, Judge, I'd rather be there in person and I'd rather look at you in the face when I get told what a disorderly conduct is and what all the things mean. I'd rather be in person. Do you want to be in person or by telephone?
Isn't it just a misdemeanor?
Yes, it sure
like
is.
Misdemeanor?
It is surely duty, highly, a misdemeanor.
Well,
It's what I have to do, sir. I have courts that say that there are certain things that I have to do on my job, on the
Okay.
record. That's one of the things I have to ask you. Do you want to do it by telephone or do you want to be here in person?
No, Your Honor. I'm fine doing it by telephone.
Excellent. Formal motion to remove domestic abuse enhancer.
So made.
Granted. So, Mr. Ramstrom, how old are you?
40?
Can you read, write? You understand the English language?
Yes, ma'am.
Any drugs, alcohol, medications, or mental illnesses or disorders?
No.
Do you understand you would have the right to go to trial? You would have the right to an attorney. You would have the right to have yourself or an attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have a right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of that?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the state would have to prove on or around February 7th, 2026 in Burnett County, Wisconsin, in a private place, you engaged in abusive or otherwise disorderly conduct, which tended to provoke a disturbance. That is a misdemeanor. Maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both. Do you understand that charge and what the maximum penalty could be?
What it could be, but we've already negotiated what the penalty is, right?
Again, I can do what I want. I'm the judge, but that is the
Well,
recommendation.
maybe I will
So,
take this to trial. I don't know why. I don't know why you can't.
sir, I just
agree on
have to do my
something.
job, sir. And the law
Okay.
makes me say all these things on the record, sir.
Okay. Yes, I understand.
All right, that could be a maximum possible penalty. The recommendation, again, from the state is a fine and costs only. So you understand that if I thought that this was outrageous and very abusive and very violent and very harassing, I could sentence you up to 90 days.
I understand, Your Honor.
All right, okay. Now, are you admitting here today that your behavior that day would meet the definition of the disorderly conduct under Wisconsin law?
Not at all.
You don't think you were
Maybe-
disorderly or you
maybe
provoked
my
a disturbance?
language after the
Oh my
fact,
God, you
but,
are awful. You're coming here in person and we're going to do this in person. I can't do it because A, you want to talk over me all the time. B, I can't look at your eyes and say, shut up. C, you're not understanding anything.
No, I understand fully. Like, I was out of line.
You were out of line. And what I'm asking you,
I was
The
not
definition-
supposed to be having contact.
the definition I gave you for disorderly conduct, your conduct that day was otherwise disorderly and it provoked a disturbance, correct?
Correct.
So you're pleading guilty to the disorderly conduct because you're guilty of that conduct, correct?
Correct.
All right. Has anyone threatened you or promised you anything for you to plead guilty today?
No, ma'am.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily.
Yep.
Do you have any questions for the court or for Mr. Schmidt, the district attorney, before I proceed?
No, Your Honor.
As to count 2, disorderly conduct without an enhancer, how do you wish to plead?
As guilty, I guess.
Are you guessing it or do you know it?
Yeah,
You're pleading guilty?
correct.
All right. The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of disorderly conduct. The remaining charges and the other case will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Schmidt.
This is minor behavior around an injunction that has since been dismissed. This is appropriate. I'd ask that you follow.
Mr. Ramstrom, what do you want the court to know? Anything? You can make a statement.
No, Your Honor.
All right.
Just like this all to be over with so I can go on with my life.
I understand the facts of this case. I understand the facts of you and your ex, or the mother of your children. I understand the situation. It is not, does not rise to an entirely serious level. You are admitting responsibility and being accountable and pleading guilty to a disorderly conduct. So I do think that it's appropriate. I don't think you're a risk to the community. Therefore, the court will follow the recommendation, $500 cash. You have that posted. You are good to go. No further money is owed to the court. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. You need to call the sheriff's department and see if they have it. If they do, you're good to go. If not, they'll just come in and request that you provide a swab of your DNA. But in a case like this, you do have the ability to request it be expunged from the CODIS system through a written letter to the Department of Justice, the Wisconsin Department of Justice, not to the court. All right. Anything else?
All right.
Not from me.
Nope, I understand that.
All right. Then we